duration of today's call. And then I'd like to turn the call over to
Good afternoon and welcome to the Advanced Practitioner Series. I'm Patrick Shepard. Very pleased to be joined today by Rachel Dowell and Leigh Francis from OGE's Ethics Law and Policy Branch. Welcome, guys.
Thank you.
Today, Leigh and Rachel are going to be reprising a presentation they delivered at the National Government Ethics Summit on 18 U.S.C. 205A. So we're very much looking forward to that, and this is part of our effort to bring some more of the summit content to those of you who attended virtually or maybe weren't able to attend some sessions. So we'll be doing some more of that in the future. Before I turn it over to Leigh and Rachel, I'd like to cover just a few quick announcements. The first one is that in December, we're going to be dedicating our distance learning events to program management and leadership. So our fundamental series will deal with model practices, and the Advanced Practitioner Series is going to provide an introduction to enterprise risk management. So if you're interested in program management and leadership topics, please keep an eye out for those. I'd also like to thank everyone who registers for these events. I know that you can just go to the YouTube account or the Google Plus page and watch them, but registration does a number of things that benefit you and OGE. One, knowing who you are helps us continue to provide these high quality training opportunities. It also allows us to provide you updates when things change, if we have new materials, and it also allows us to solicit your feedback. So after today's presentation, like all of our presentations, we'll be distributing to you a course evaluation. Please complete those. Your feedback is extremely helpful to us, and we do use your comments to help steer the direction of IEG events in the future. Also like to thank those of you who have been completing those in the past. Finally, I'd like to remind you about the Institute for Ethics and Government store on the Max community. If you're looking for tools that you can use in your programs, you can find tools that are developed by OGE and also agency ethics officials in the IEG store on Max. So please look for that. So again, I'd like to welcome you guys, and I'd like to welcome our guests, Leigh Francis and Rachel Dowell. Welcome, guys.
Thanks so much.
And good afternoon, everyone. Welcome to the Advanced Practitioner Series. As Patrick said, I'm Rachel Dowell here with Leigh Francis, and we are assistant counsels in the Ethics Law and Policy Branch here at OGE. So today we're going to talk about 18 U.S.C. Section 205, which is one of the two criminal conflict of interest statutes that deals with an employee's private representational activities, the other being 18 U.S.C. Section 203. Specifically, we're going to really focus in on 18 U.S.C. 205A2, because that's the section of 205 that arises most frequently and is most likely to affect executive branch employees. So Patrick's going to pull up a PowerPoint for us so that we can all follow along. And we've also given you a flowchart on the Max website with all the elements of 205A2 that we're going to cover and a lot of the citations that you can refer to. So that's going to be a really handy two-pager to refer to after the course. So to start off, I just want to give everyone a quick overview of the structure of 205 and kind of summarize the other provisions so that we have, our bearings as we examine 205A2 in more detail. So starting off at the top, you'll see that there are two clauses that make up 205A1, and these apply when there are claims against the United States. So Leigh's going to discuss what that means in more detail, but basically, matters that qualify as claims against the United States are pretty limited. So really the main focus for agency ethics officials is typically going to be 205A2. Now the restrictions in 205A1 and A2 apply to all federal employees and all employees of the judicial and legislative branches other than elected members of Congress. So moving on through the structure of 205, next you'll see section 205B, which is basically applies the same restrictions in 205A1 and A2 to employees of the District of Columbia in connection with claims against DC or matters in which DC has a direct and substantial interest. Now, executive branch employees do not need to worry about 18 U.S.C. 205B unless they happen to be employees of the Office of the U.S. Attorney General for the District of Columbia. Now, these employees are unique in that they're subject to both 205A and 205B. So moving on through this little chart, we have 205C next, which provides that special government employees are subject to less restrictive prohibitions under the statute. And I'll touch on that briefly later on. Then we have 6 exceptions to the restrictions of 205A and B. And then mixed in there, we have the definition of covered matter, which is an important concept to use when interpreting 205A2.
Thanks, Rach. So I actually really like training on 205. It's one of the oldest statutes, and hopefully this will be of help for all you practitioners out there in the field. So as Rachel indicated, there are 3 offenses in 205A that apply to employees of the federal government, not including, again, employees of DC. We're going to be focusing on the 3rd, which is 205A2, because in our experience, that's the one that usually comes up the most, and we get questions for from the ethics officials in the community. Because we take a look at them, I just want to explain the purposes behind 205, going back through legislative history and also some treatises by Bayless Manning. So there are at least 2 your official position to benefit others. This is use of influence or government position. The second one is the idea of conflicted loyalties. In the first one, it's your knowledge of the government and perhaps your prestige in that position that we're concerned about. And the second one is more of, well, if you're working for somebody on your part-time and then you're working for somebody else on your official time, how can we really be assured that your integrity, your loyalty is directly to the federal government? So that's just kind of the purposes behind those 2. And then one other quick aside, for me, 205 was a little difficult to get my hands around at first, but something that kind of helped me conceptually to get an understanding of it is by looking at the ABA model rules. So 205 in many ways is an analog to ABA model rule 1.7, which deals with concurrent conflicts. And it generally prohibits representation of one client, where that representation will be directly adverse to another client. So in many ways, for those attorneys out there, 205 is simply a criminal prohibition put out there by the government on its employees that mirrors Rule 1.7. Now let's go right to the text. First, we're going to take a look at 205A1 and its 2 prohibitions. And then we'll contrast those with 205A2 and how those both work together. As Rachel said, 205A1 is unique from A2 in that it only applies to claims against the United States. Again, A2 talks about covered matters, which we interpret as particular matters. The question then becomes, what are claims against the United States? Well, courts have said they are claims for money or property, but only that and nothing more. Thus, a lawsuit to compel an agency to issue or rescind a regulation or to interpret a statute in a particular way just would not qualify. A 1999 U.S.C. opinion, on the other hand, makes it quite clear that a petition for attorney's fees is a demand for the payment of money by the United States, and as such, falls within the meaning of the phrase claim against the United States. So if there is no claim, there is no 205A violation to worry about and no analysis to worry about. Now let's take a look at A2, which applies to covered matters. Now, again, that should sound familiar to everybody out there in the ethics community. It's almost the same language as 18 U.S.C. 208A. So basically, in this context, you can apply what you know about 208A and the term particular matter to 205 and this section with covered matters. So just to explain that a little bit further, basically covered matters or particular matters are matters involving deliberation, decision, or action that is focused on the interests of specific persons, for example, grants or contracts, litigation, investigations, or focused on the interests of a discrete and identifiable class of persons. That can be rulemaking, regulations, etc. And again, from OG's own regulations, particular matters of general applicability, as we call them, are regulations. They could be regulations on safety standards for trucks or meat packing facilities, and or policies regarding government loans to owner-operators of small farms. Now, however, again, covered matters does not extend to consideration of broad policy options that apply to a very large and diverse group of persons. For example, a covered matter would not include or bar representation on tax or Social Security matters that would affect most Americans. To get to 205A2, I'm just going to go a little deeper into 205A1. First, we'll start at the beginning with Clause 1. And like 205A2, 205A1 Clause 1 bars activity known as acting as agent or attorney. I'm going to get to what that means in really, really deep detail in a moment. But suffice it to 205A2. But just to be more specific, how Clause 1 and 205, Clause 1 of 205A1 and 205A2 interact. Let's just say that if somebody were to violate Clause 1 of 205A1, that employee would also violate 205A2. And by what I mean by that is a claim is a particular matter. So
would it be fair to say, Leigh, that the provisions at 205A2 are more expansive than the provisions here at 205A1?
Yes, that's absolutely true. So with regard to Clause 1 of 205A1, you're going to trigger that, and you're also going to trigger 205A2. Okay. And 205A2 is broader, as you said, because it covers particular matters.
So, Leigh, there would never be a case where you violate Clause 1 of 205A1 and you don't violate A2, is that correct? That's
absolutely right. Again, the 205A1 Clause 1 is narrower than 205A2, but once you trigger that first clause, you're also going to trigger 205A2. Now we're going to move on to the second prohibition. I think this one's really important. I want to flag this for everyone because it's the only place in 205 that reaches behind the scenes activity. So first we're going to take a look at that, and that's on your slide. And so I'm going to go term by term. First, we're going to break down the term gratuity. Now, I think it's a rather odd word to be used here because in layman's terms, gratuity is usually, gratuitous and not given as consideration. However, in the end, it has been interpreted or construed as simply meaning compensation, something of value in exchange for assistance.
So when we say the word gratuity, we are to understand that what we actually mean is compensation or something that's compensatory in nature.
That's exactly right. It isn't something that is gratuitous as you might think of in the tax code. There's gratuitous gifts and so forth and so on. For 205, it's consideration as you would understand it.
Okay, well that's an important thing for us to keep in mind.
Absolutely. So to violate 205 A1, again, Clause 2, you would have to receive a gratuity, which is, like we said, compensation. And again, this only applies to behind the scenes assistance. So what you have is you're getting paid for behind the scenes, and so I just want to really flag that because it makes it unique. And if compensation, for both the reason that they have to be paid and also that you don't have to be speaking to the government. And I just want to add one quick thing. Believe it or not, in this one way, Congress actually narrowed 205 from its predecessor, which was 18 U.S.C. 283. That was changed back in 1962. And Congress narrowed 18 U.S.C. 283 when it passed 18 U.S.C. 205 because 283 actually prohibited uncompensated assistance in the prosecution of a claim against the United States. So they added that as a required element. Next, we're going to move on to the term assistance. While there's very little law on the term assistance, presumably this means conscious or knowing assistance. And assistance also presumably reaches behind the scenes activity that is of significant help or use in the prosecution of a claim. For example, it might be interviewing potential witnesses. However, just how far assistance reaches is not clear, and there is presumably some de minimis forms of assistance that would not be covered by the prohibition. For example, where the help is not significant and is essentially ministerial, for example, copying assistance, particularly when rendered without knowledge of the relationship to this claim, that probably would not violate Clause 2.
So this bears some similarities to our thoughts under 18 U.S.C. Section 208. When we talk about personal and substantial participation, we have that kind of ministerial idea that there are things that are other than substantive participation.
I think that's right. I mean, I think there are some significant similarities between those two lines of thought, and so that's pretty much what we've been understood when we're talking about 205.
Excellent.
Lastly, as mentioned before, the term claim means claims for money or property. U.S.C. has said that whether a claim is the United States should be focused on whether the United States has a significant monetary interest at stake in the lawsuit. And the position of the United States as plaintiff or defendant is not controlling. Now we're going to move on to the heart of the matter, which is 205A2. And let me go through the elements of 205A2. I have them as 7, and I'll try to refer back to all 7 as best I can as we go through. Because again, I think a lot of people, this is what people get a lot of questions on, and I think a lot of people are concerned about when people come to them regarding outside activities. So the first element is being an officer or employee, may not, and then 2, act as agent or attorney, 3, for another. 4, before a department, agency, or court. 5, in connection with a covered matter. 6, in which the U.S. has a direct and substantial interest. And finally, 7, other than in the discharge of his official duties. So that was 7 elements. Again, I'll try to refer back to them and where we are in 205A2's analysis throughout. Starting at the beginning again, as we mentioned, 205A applies to federal employees with a special narrowed application to
highlighted here because this is kind of the crux of the matter.
Yeah,
this is the difficult part of the analysis.
Yeah, that's exactly right. This is where we're going to spend a good deal of time. Perhaps the majority of our time today is discussing simply acting as agent or attorney. So thank you for highlighting that, Patrick. There's basically what we found is there are 3 layers of meaning that have percolated down through precedent and through interpretations by OLC and OGE since 205 was passed. I'm going to go over the first layer, which focuses on the literal language of the statute as to whether or not one is acting as agent or attorney. And then Rachel's going to take the latter 2.
It's so complicated. We need 2 people to cover this
Yes.
yet. Good. Well, we're all waiting, and they're very excited because I agree that I've been doing this for a while. And when I first, came to this statute, this was the part that was not immediately intuitive and takes a lot more thought than it initially appears.
Yeah, to act as agent or attorney is kind of a loaded term. There's a lot in there, and then it's hard to understand unless you really break it out into these 3 sub-elements.
Yeah, it's probably not the right term, but there's kind of a common law that's built up around a statutory language, which those are usually inconsistent with each other. But the bottom line is when it comes to interpreting this, we got these layers. And so that first one, like I said, is that literal language of acting as agent or attorney. And this I have represented on the slide as actual or apparent authority. So I just want to highlight that for you. Again, I'll then turn it over to Rachel to give you a little preview to discuss the second layer, which is a direct communication, and the third layer, which is intent to influence. And that third one's also very important and also not directly in the statute, as Patrick mentioned. All those elements, again, must be shown, but again, they're not really explicitly listed in the statute. So the first layer. This first layer in many ways goes to the legal status of the federal employee in relation to the person whom he is potentially representing. First, acting as an attorney, I hope is pretty self-explanatory, but let me give you a little bit of nuance with that. It can be broader than the typical attorney-client relationship. And one example of that is it covers situations in which an employee would like to serve as a master amici. I'm probably mispronouncing that, but that's how I read it, which is a unique role in the Court of Veterans' Appeals. And that's where you take on the role of an attorney without actually being one. The Office of Legal Counsel in the Department of Justice has said functionally, master amici would perform a role nearly identical to that of retained counsel. OLC thus concluded that the employee would act as an attorney for the veteran. Now, while acting as an attorney is fairly clear, acting as agent is a bit more complex, and again is represented on the slide by actual or apparent authority. Actual or apparent authority are agency law concepts to which we'll now turn. And I think if we had the heart of the matter, this is the heart of the matter, the heart of the matter.
Fantastic.
All right. So let me just start by saying, gotcha, you got me, thanks. Let me start by saying, in essence, what we're getting at here with actual or apparent authority is whether from the perspective of the government employee, whether from the perspective of the government, the employee would be an agent of another when communicating to the government. And now this is based on O'Neill versus HUD. And in that, they said an employee would be an agent of another when communicating to the government if the employee has actual apparent authority. And basically, according to O'Neill and agency law principles, I'm going to show you what that means. And to drive down further, there are 3 routes to getting to actual or apparent authority.
So when we get to prong 2, we go down 3 layers.
I swear I
prong
have
2 of
here.
step 2 of 6. Then we
So
go.
there's 7. Let me see if I get this right. There's 7 elements. We're in the second one, acting as agent or attorney. There's 3 layers to that.
Right.
We're in the first layer of that.
We're in the first layer, and there are a few more layers.
There's attorney, which everybody understands except for the master amici, and then there's agent. And to get to agents, we have these three routes.
Three routes, yeah.
Yes, these three routes. So everybody.
Excellent. All right. So
glad everybody
I think I'm caught up now. I know where we are.
There's a flow chart that I'm going to send out after
Yeah, the
this.
flow chart is key. I think.
Yeah, I find the flowchart to
Yeah.
be really helpful. And
Excellent.
we did share that on the Max page. So those of you who are looking for that, you can
Excellent.
find it on the course page.
All right. So these three routes. All right. And to flesh out, sorry, thanks, Rich. To flesh out these three paths, I broke actual or apparent authority requirement in 2 questions on your flow chart. If you have that, I definitely refer to that now. And if not, please do download it after this seminar today. So let's start with the easiest route first. The first one is, based on the facts provided by him. So based on what an employee tells you, the employee would be an agent under the common law and would be acting with actual authority. And incidentally, I imagine this is how most, if not all, 205A2 questions are styled. As presented in the flow chart, what we would ask is there an agency relationship between an alleged principal and the employee/alleged agent? So under the common law definition of agency, we ask 1, has the alleged principal agreed that the employee should act on the principal's behalf and subject to the principal's control? And 2, has the employee agreed to so act? Many outside business relationships you think of are agency relationships. For example, when a federal employee is also an employee of an outside organization, that is an agency relationship.
Because employment comes with some control and consent from both parties.
Absolutely. That's
Okay,
absolutely
that
right.
makes sense.
And, you have loyalties to your employer, and there's also a lot of agency law concepts that deal with that. However, I put the question of whether an agency relationship is present separate on the flow chart, mostly because I think it is worthwhile to ask and think about apart from actual apparent authority question. And the reason I think it's worthwhile is because, while certain relationships between 2 individuals as a matter of law are not agency relationships. And here are some examples. For example, the DC District Court had found that when an attorney hired a process server, the process server was not an agent of the attorney, and thus as a matter of law, the attorney cannot be liable for the actions of the process server. Also refer to the restatement third of agency. If you have that, take a look at it. If not, let me know. Give me some questions. I can give you some answers with regard to that. According to the restatement third of agency, a director on a corporation's board of directors is also not considered an agent of the corporation because the shareholders do not have a right to control directors by giving them binding instructions. Finally, according to the restatement third, if an individual is retained to give an independent assessment, such as a consultant or I'll mention now expert witness, the expectation of independence is in tension with the right to control, and thus there might not be an agency relationship. And these are termed by the restatement non-agent service providers. Again, the essential element that we're focusing on here is whether the alleged principal has the right to control and direct the agent in the performance of his work and in the manner in which the work is to be done, or as we say at OGE, has some degree of control over the agent. When there's no control over how an individual achieves a task, usually there's no agency relationship. So I'll refer back to the flowchart if everybody out there has it. Basically, we ask, is there an agency relationship? If yes, as when someone's an employee of an outside organization, we go to the flowchart and then we ask whether the agent has actual or apparent authority to make a communication to the government. If the employee is not an agent, I just want to mention that almost all the time, you're not going to have a 205A2 violation, but I'm going to come back to the almost.
So there's an almost. So
there's an almost.
So,
yes,
so we can do the agent analysis, but that's not the end of it.
That's not the end of it. That's correct. And the reason I say that is because you still have to ask for those non-agents whether there's apparent authority that is present.
Okay, so we have to have agency or apparent authority.
That's right. I mean, that's right. So let's assume we have an agency relationship before us. Just to kind of flesh this out, we ask whether the agent has actual apparent authority to act on behalf of the principal. And what this focuses on is what exactly the principal and agent have agreed that the agent will do. So I'm going to give an example of when there is an agency relationship and there is actual authority. The example goes like this. A government employee, Andy, works part-time for a Fortune 500 company as a financial analyst. Further, let's say there is an SEC investigation of that Fortune 500 company, and Andy drafts correspondence that is sent to the SEC as part of its defense against the SEC's charges. There is clearly an agency relationship And within the scope of his job, as agreed upon by the employee and the Fortune 500 company, he has sent the correspondence to the SEC. So there we have agency and actual authority, and we would have a violation there, assuming all the other elements were present.
Excellent. I think that's pretty straightforward.
Okay.
Acting on behalf of the employer as an employee, making representations, then we have an issue.
Everything falls.
And that's
in line.
probably how most of the 205A2 problems are going to come up, right?
Absolutely. No, I think that's normally what occurs. But because we're trying to go in depth here for all the advanced practitioners out there, I'm going to flesh out these other two routes. And now we're going to do an example where there is an agency relationship, but there's not actual authority, just to kind of flesh this out further. Andy now works, same situation. Andy now works part-time for a Fortune 500 company as an IT specialist. Further, let's say we have the same SEC investigation of that Fortune 500 company, and Andy calls to advocate for the dismissal of the investigation. He calls and says he's an IT specialist at the company and that he's never seen any illicit or corrupt activities, and there's no merit to these charges and they should be dropped. Now, unless shown otherwise by the facts, Andy does not appear to have actual authority to advocate before the SEC regarding the investigation and probably would not violate 205A2.
Because it's not within the scope of his duties as an IT professional,
Exactly.
to advocate before SEC on behalf of the organization.
Precisely. And the government, and I'll get to how do we flesh that out and how we come to that conclusion. And so, again, agency's relation is the relationship that is usually present, and actual authority defines the scope of that relationship. Both are typically needed for a 205A2 violation. And again, as Rachel said, this is usually what we get questions about. Now we're going to move on to the last two routes, and specifically the second. And the second one is probably not as complicated as the third. But this is where an employee is an agent under the common law and is deemed to have apparent authority. To briefly discuss apparent authority, it helps again if we use another hypothetical. So I'm going to refer to the same case as before. Andy is an IT specialist. There's an SEC investigation of his employer. However, Andy is now present in a meeting to lend technical support to the company's senior executives. The senior executives are participating in a video teleconference with their attorneys and SEC investigators. Andy, of course, was not hired to do anything but provide IT support. However, during the video conference, he speaks in support of an argument made by a senior executive. The government does not know that he is merely an IT specialist, and the senior executives, well, they like his point. So they just say nothing and go along. So the second case is where the employee is an agent, as we defined earlier, and acts on behalf of the principal. But of course, when he does so outside the scope of his actual authority here, and his actual authority is to do IT work. However, here, we're going to say that he has apparent authority.
So while he doesn't have actual authority, the circumstances suggest to us that he has apparent authority, and that would be that's covered under the rule.
Precisely. And basically, just to summarize exactly what you're saying, what that means is because of the actions or acquiescence by the principal.
Right.
And that's not, I want to make that real clear distinction. This isn't what the agent is doing. This is something that is or is not done by the principal. It is reasonable for the government, which would be the SEC investigators here, to believe the agent had authority. And as such, under both the common law of agency and 205, the employee is deemed to satisfy this element.
Okay, I think that makes sense.
Okay, great. And let's see, another example, I just want to give some examples of where apparent authority might be there for agents, is when corporations situate people within the hierarchy of positions with defined responsibilities. So employees of a corporation might not have actual authority to make certain communications, either because it's not part of their job or because their boss explicitly told them not to act. But by the principal placing that employee in that senior position, the principal has acted, and if it's reasonable for the government to believe the agent has authority in that situation and can prove it, a 205A2 violation can lie.
Okay.
So I'm going to summarize the second route. There's an agency relationship that is present, and there's apparent authority. As we talked about, substantially different from agency and actual authority, because, again, this requires action or acquiescence by the principal that the government sees or knows of for a violation to occur.
Interesting.
We'll move on finally to the third route, and I'll turn it over to Rachel very soon. Finally, let's see, the third route for actual apparent authority. This is, again, our first layer of acting as agent or attorney. It's the same case as above. I'm going to refer back to our hypothetical, except Andy does not work for the Fortune 500 company. Instead, he works for company X, which was hired by the Fortune 500 company to provide IT support and assistance. Andy is not an employee and only performs assignments as provided to him by company X. If Andy were to speak in the same way at the meeting that I just described, and the Fortune 500 company's senior executives, again, said nothing and acquiesced and did nothing, from the perspective of the government, it's reasonable to conclude that Andy was acting as an agent for the company. So 205A2, a violation might lie, at least as to this element, would be satisfied.
So this is a case where there's not an agency relationship between the Fortune 500 company and Andy, right? Because they don't exercise control over him, and there's not we don't have those elements that we discussed during agency.
Precisely.
But the fact that there's apparent authority means that, notwithstanding that fact, we can still have an issue.
Yes, and this goes back to my almost hedge, which must have been 20 minutes ago. But in any event, right. So in this third situation, there's no agency. However, the Fortune 5 company has done something or acquiesced by liking what he said, by putting him in that situation, by letting the government believe that he has that authority. And so these are our three routes. Again, these are how you can violate 205A2. I don't know if I've ever actually gotten a question that implicates this, because we prudentially advise, of course, our employees about how to stay far away from such situations.
Right. And this strikes me as something that's so fact specific that it's probably more a concern when you get into the enforcement side of things.
Yeah, absolutely.
And you're going to be more conservative than this in the prospective advice giving. So it's interesting and important for us to know as advisors. But probably more important when we get to enforcement type actions.
Yeah, absolutely, and that's something I'd just like to second. Is I'm explaining this because these are what I believe are the parameters, the strict parameters of 205 as put down by case law, U.S.C opinion, ledge history, OGE opinions. I think that you should know that so that you can advise prudentially far away from that.
Excellent. No, that's extremely helpful.
Okay. All right, and so action, by the principle, I just want to talk about a little bit action by the principle that can create apparent authority. It can be spoken or written words. It can also be through prior patterns of conduct or practice. So I guess one last thing I want to point out before I push it over to Rachel is that though 205A2 in many ways, and I think in many people's opinions, is extraordinarily broad, 205A2 is actually narrower than 203 and 207 in at least one way. And that's for a 205 violation to occur from the perspective of the government, the employee must be acting as agent when making the communication. While 203 or 207 violations could potentially occur where an employee or former employee communicates or appears before the government on behalf of another, and the employee has no actual or apparent authority to act. And we have some good OGE legal advisories on this. Diagram 07015 talks about where expressing an opinion of another to an agency in an immigration support letter would not trigger this element unless the employee was influenced or controlled in drafting and submitting the letter. And then the other one I'll just quickly mention is advisory 01X1, and that analyzes whether acting as a compensated agent for private clients in prosecuting patent applications violates 205. And no surprise here, it does. And so last thing I want to point out, just as Patrick mentioned, this is an intensely fact-specific analysis. Prudentially advise your clients quite a distance away from what exactly I've delineated here for you.
I think that's one of the scariest things about 205 is that it's not tremendously intuitive, and the concepts that seem to have sharp corners turn out not to. So using caution when we're providing advice is really important.
Certainly. And hopefully this provides ethics officials with a little bit more confidence when they are providing that.
Excellent.
I'll now give it over to Rachel, and she's going to pick up the second layer of element 2.
Yeah, so we're not done with this term acting as agent or attorney yet. And, as we said, it's easier to break that down into those 3 sub-elements. Some are broken down more, but the 2 other sub-elements are just as important as the first one, which was actual or apparent authority. There also needs, first of all, to be a direct communication. So a communication itself is pretty self-explanatory. It can be oral, written, electronic, etc. But the communication also needs to be between the employee and another government employee. So if I go over to the Social Security Administration, for example, and on behalf of my friend, I argue her entitlement to benefits, then I'm going to be meeting this direct communication requirement because I'm talking right to another government employee. But if I just advise my friend about what she should say when she goes to the SSA, then I'm not going to meet that requirement because that type of behind-the-scenes activity is consisting of a communication that is only indirectly addressed to the government. Also, just serving as an officer or otherwise with an outside organization, and even if someone else at the organization is contacting the government. Because remember, it's this representational communications of the employee that are implicated under 205, not just outside activities in general. So the third sub-element of acting as agent or attorney is there has to be an intent to influence in that communication. So that means that the communication needs to be made in connection with a matter on which there is some controversy or at least the potential for divergent views. So again, if I argue to the Social Security Administration on behalf of my neighbor that they erred in denying her benefits, then the content is adversarial or at least potentially adversarial. On the other hand, if I go over and ask for a certain form, then my communication is probably going to be just ministerial in nature. So when you're just seeking factual information of a routine nature, there's not likely to be any controversy and thus no intent to influence.
So that's very similar to some concepts we see elsewhere in the ethics laws and regulations where, you know, we need some kind of substance, and in this case it has to be of a controversial nature, and merely ministerial speech the government might not qualify.
Yeah, that's right. And I think 18 U.S.C. 207 and our regs are really instructive on this concept too. And also, I think finding if there's an intent to influence is really fact specific, and it's a really low bar. So, it has to do with something where there is just any potential for controversy. So when advising on whether there's an intent to influence, I'm really cautious on telling people what they could and couldn't say to us.
So this often isn't an element where you want to stint when you're advising employees. You want to say, please don't make representations before the government, and maybe be very, very careful if you're going to authorize or advise that they communicate with the government.
Yeah, this isn't the part where you want to skirt the line saying it's only going to be these ministerial communications, because in 1 second it could become communication where it's controversy.
Yeah.
So, but with that said, though, there are certain communications that, as a matter of law, are not made with the intent to influence based on Office of Legal Counsel and OGE opinions. So, for one, preparing and signing another person's tax filing as preparer does not in itself violate 205A2. Similarly, OGE has found no intent to influence when an employee files an SEC Form 10K or similar disclosure form required by the SEC. So these are all going to be considered statements of fact, where the employee is not really advocating that the facts be interpreted in one way or another. And there are other types of tax or financial filings out there where we might advise that filling out the form on behalf of another person, when it amounts to merely attesting to the facts provided, is okay under 205. But you're really going to want to take a look at each form, each situation, and determine whether it's truly a factual attestation or if it's really advocating that the facts be interpreted in a particular way. So I do really want to emphasize here that although it's technically permitted, it's always going to be risky to fill out these forms on behalf of another, because that's really about all you can do. So after you sign, you're going to have to avoid any other contacts with, the agency you're submitting the form that could constitute, arguing what's on the form. So if they're later audited or investigated based on that form, then any representation regarding that audit or investigation could violate 205. So you're really better off finding another person to represent organizations in those types of cases.
I think that's a really important thing to communicate when you're advising employees, because they may be familiar with some of these determinations that OG's made, but to make clear that subsequent communications could move into the area that's covered under the statute is really important.
Right. And a lot of times, if you're the one who's signing a form, I guess there would be an expectation that you're going to defend what's on the form, which could get you into this risky area for 205.
Yeah. And the only thing I want to point out is it doesn't have any limitation on the type of organization that you're speaking about. It could be a great organization. It could be it could be any organization. And for the law, it doesn't matter. So some people might get lulled in a sense of this shouldn't be a problem if I'm talking for 501c3. It just doesn't matter.
It doesn't matter the nature of the organization. It's the use of the apparent authority of government.
That's right.
Yeah, that makes sense.
All right, so we're finally going to move on out of that acting as agent or attorney element and onto, I think, what our third element here. And so that would be you have to, on behalf of another. The communication has to be on behalf of another. So 205 actually states in the text of the statute that an employee may not act as agent or attorney for anyone, but 205 has been interpreted as not barring self-representations. So really you have to act as agent or attorney for another, not just anyone, which I guess could include yourself. So that's why we have the term on behalf of another as opposed to using the actual language in the statute. So you can speak on your own behalf or on behalf of your sole proprietorship without running afoul of 205. For example, then that representation is on behalf of another because there's this separate legal entity involved.
In my experience, employees have trouble understanding that distinction, and it's really important to make clear that when it's a wholly owned corporation, there is another legal person, and that while materially it seems very similar, it is in fact not under the law.
That's right. And an easy way to figure out if you're, the person's filing on behalf of a sole proprietorship or another legal entity is to look at their tax filings. And if they're filing, their sole proprietor business with their personal tax forms, then that's just one entity, and that's yourself.
Right.
Yeah. And the only thing I want to mention, I think, is the point about your right to your self-representation, I think, derives from the Constitution and the right to petition the government. And so that's what we're really driving at here.
Yeah. So because Section 205 doesn't prohibit self-representation, that means an employee can represent his own views before the government in connection with a particular matter, even if those views are the same as those held by an organization in which they happen to be a member. The communication just can't be as the organization's representative. That's the key there. Likewise, writing letters of support, like support letters for a sentencing hearing or immigration support letters, are going to be okay because the mere fact that such a letter is in support of another's position or otherwise benefits that person in some way doesn't mean that the federal employee who's writing the letter is necessarily under control of that person, going again to that agency relationship.
So we need more than just an alignment of interests.
That's right.
So if I'm similarly interested to another person and I make a representation that is in alignment with their interests, but there's no element of control or acquiescence, is that kind of what you're getting at here?
Yeah, and this kind of blends in with Leigh's discussion about actual or apparent authority. It's really key that you're doing it on behalf of someone else, and it's not just helping someone else.
Right.
Again, because back to the purposes. Otherwise you're not talking about why this was passed, which is leveraging your influence or having your split loyalties. What are your split loyalties to?
Excellent. That's helpful.
So another thing that's interesting with this part of this element is that acting as agent or attorney for anyone is not going to include the United States. So 205 is not going to bar a representation on behalf of the United States government, even if it's outside the proper discharge of your official duties. So it's kind of interesting. That's often an exception for our statutes, but here it's just read into on behalf of another. Okay, so next up, the communication has to be before a department, agency, court, or one of the other specified federal entities listed in the statute. But really, we're going to focus in on what a department, agency, or court is under 205. So department and agency aren't actually defined in 205. So we have to look to 18 U.S.C. Section 6 for these definitions. And there you're going to see that a department means one of the executive departments, meaning a strictly federal departments. An agency embraces only agencies of the United States. So that's going to include entities within the legislative branches, like the Office of the Architect of the Capitol. And it's probably going to include agencies within the judicial branch, like the Administrative Office of U.S. Courts. But OLC has not expressly opined on that one. But I do want to make it clear, it doesn't prohibit you from going before Congress or its committees. It's just those legislative agencies. And OLC has also determined that 205 does not prohibit employees from communicating with state agencies. So it's really only these federal level U.S. agencies. Now, this gets a little trickier when it comes to agencies of D.C. because it's really not obvious whether, the drafters wanted to encompass D.C. in this definition. And also the term agency is used in 205B, which is the part that applies to D.C. employees. So there was some question there for a while, but OLC has determined that because there are other separate provisions for federal and D.C. employees, that the definition of agency in 205A is only going to apply to federal agencies and not include agencies of D.C. So moving on, just to cover court really quickly, that's again not defined in Title 18 at all, like agency or department is, but the Office of Legal Counsel has shed some light on what they mean by court. So OLC has concluded that the term court means any court, state or federal. So 205 could apply to representations before both federal and state courts, which is, I think that's pretty broad, and I don't think that's a obvious reading of the statute there.
Yeah, I agree. I think this is an area where I was surprised when I came upon it the first time, and it's an important one to highlight and remember when you're thinking about 205.
Yeah, there is a saving grace. So in state courts, you have to remember there has to be, the U.S. has to be a party or have some kind of direct and substantial interest. So, for state courts, that nexus is probably not going to be as common as in federal courts. So that is a little bit of a save for some employees there. And finally, I think it goes without saying that department, agency, or court is not the building, it's the people. So you can't contact an agency employee in their official capacity, even if they're away from the desk on the golf course somewhere outside of work, because they're the employee is the agency for purposes of 205. It's not limited at all to formal appearances or proceedings.
That's also really important to remember. You don't need a formal meeting, you don't need a formal hearing in order to implicate this law.
Right.
Excellent.
Okay, so moving on, as I mentioned before, the employee is prohibited from acting as agent or attorney before a department, agency, or court in connection with a covered matter in which the U.S. is a party or has a direct and substantial interest. So you might be kind of familiar with this term from other statutes. But there is no statutory definition of the phrase direct and substantial interest. But again, it does appear in other criminal conflict of interest statutes like 203 and 207. So even though we don't have a lot of guidance in respect to this term for 205, we can look to our guidance interpreting Section 207 to provide, what the scope of this phrase by describing, its application in the context of 207.
I think that's a good thing to remember in general. The two laws share a lot of concepts, and while we don't have a regulation for 205, we do for 207. Mm-hmm. So some of that definitional work that we've done in 207 can be instructive in these analyses.
Right, and the 207 analysis in our regs is pretty helpful because it actually sets out factors that you can kind of weigh when you're making this analysis. So I find it very useful, but I do want to just flag that Section 205 is going to be a lot broader than Section 207 because for 207, you're looking at whether one agency or one component has an interest, which is that's in a 207A situation in any way. But for 205, you're going to have to figure out if any agency is a party or has a direct and substantial interest. So that could require, a number of different agencies or offices be consulted just to ensure that the government doesn't assert such an interest.
Is that something, if you had a question about that you might find yourself as an ethics official reaching out to someone at the other department or agency to help in that analysis?
Yeah, I think that's really helpful to kind of, depending on, I think you can kind of recognize what equities, what might be involved and kind of flag certain departments that might have an interest and kind of reach out and see whether there is indeed an interest there.
I think it's a good practical tip because I know as a desk officer, I've received that question before, right. and collaborating with other government agencies and departments has been very helpful.
Right. Mm-hmm. So, but generally though, the U.S. doesn't necessarily have a direct and substantial interest merely because a federal statute's at issue, or a federal court is serving as forum. That alone isn't enough. There also need to be some greater interest than that. You're always going to want to be careful too, because even if it's determined that the U.S. does not have a direct and substantial interest right now, such an interest could arise while the matter proceeds, which would trigger that statutory bar at that time. So one example is, you're not per se barred from representing another person in a bankruptcy case. Because the U.S. really only has an interest if they are a creditor or otherwise, have an interest in the proceeding from the standpoint of tax liability. But, in those types of cases, the U.S. always has the right to intervene. So if you see a person wants to, represent another in a bankruptcy case, it's always advisable to let them know about this and in some context tell them maybe to stay away from the bankruptcy cases, which is what we do when we advise federal attorneys who want to do pro bono work.
All right, thanks, Rachel. I'm going to take over for the next element, which is other than in the discharge of official duties. So an employee will not be in violation of 205 if the activity is in the proper discharge of their official duties. Because the statute uses the term, quote, official, it's implied that the focus of the provision is aimed at barring actions taken by employees in their private capacities. Congress did not intend to limit the ability of federal agencies to assign employees to tasks that would involve they're representing other parties. However, it should be noted that there is a difference between discharging an employee's official duties and merely being allowed to engage in activity on, quote, official time. For example, when an employee is on administrative leave, he or she is given official time for some activity, but the activity he or she undertakes during that time is not part of his or her official duties. Determining whether a representational activity is in the proper discharge of an employee's official duties requires the employee's official supervisors to make a factual determination of whether the proposed representational activity falls within the scope, again, of an employee's official duties, that is, whether the activity is part of the employee's job. I just also want to note one thing. I don't have the site memorized, but there is an interesting OLC opinion involving the EPA where if it was integral to the statutory scheme, I believe an IPA detailee might be permitted to represent a state government in working in achieving his official duties. I can try and remember the site another time. I'm going to kick it back over to Rachel to speak about special government employees.
Yeah, so really briefly before we move on to all the exceptions, I want to note that for special government employees, or SGEs, the application of 205 is going to be different than for most employees. So as you're probably aware, an SGE is an employee appointed to perform temporary duties for not more than 130 days per year. So an SGE is generally considered an employee for most federal ethics laws and regulations, but at the same time, they almost always have other jobs outside the government. So it's really important to figure out how 205 applies to them. So for 205, an SGE's private representational activities aren't going to be as restricted as they are for a regular employee. Basically, if the SGE works for less than 60 days, then the restrictions in 205 only apply to party matters that the SGE personally worked on while in government. Now, if the SGE works between 60 and 130 days, then the restrictions of 205A apply to both party matters they personally worked on and any party matter that's pending at the agency. But it's never going to reach to all covered matters like it does for regular employees.
Excellent. So that's another area where understanding the concept of party matter becomes for practitioners.
That's right.
Sort of a fundamental concept. And in fact, we covered it in our fundamental series last week.
Great.
Oh. All right. And now we're going to walk on to some exceptions. I'm just going to run through them, just go through them all, and then we're going to talk about a few in particular. Usually the ones that usually the ones we're going to talk about are the ones we get the most questions about. So first, there's 205 D1A. Generally, this permits employees to represent other employees in connection with certain disciplinary, loyalty, or other personnel administration proceedings. There's a lot of opinions on this. I think that OLC has put out exactly what that entails. So those are very helpful, and I can perhaps send some your way if you have any questions about that.
Yeah, and if we have links, we could add those to the Max page if there are some particular opinions that would be helpful.
Yeah, there are some really good light posts, guide posts that have already been put out about that exception.
Excellent. So we can get those added to the Max page for those of you who are on Max.
Excellent. Section is 205 D1B. That permits employees to represent nonprofit employee organizations in certain circumstances. And I believe that was added after a specific situation, and then Congress came in and added that one. Third is 205E, and that permits the representation of an employee's parents, spouse, child, and certain other persons with whom the employee has a unique relationship. And correct me if I'm wrong, Rach, is that the one we put out in LA about recently?
We did. We put a recent one out about step parents and stepchildren.
Excellent. I think that was 2012 or 2013.
Yes.
Yeah, so that one kind of explains the outer ambit of who might be included within that representation. Fourth, 205F permits SGEs performing work under a government grant or contract to represent private entities in limited situations. Fifth, 205G permits the giving of testimony under oath and the making of statements required under penalty of perjury or contempt. And then last, 205I permits representations pursuant to certain statutes that deal with labor management relations. Okay. I'm not going to go in order per se, but first I'm going to talk about 205G, and then I'll turn it over to Rachel. So this seems pretty straightforward. Employees can provide testimony under oath or make statements under penalty for perjury or contempt.
I imagine our judges appreciate this specific provision because
They do. They very much do, and we can talk about it. I'm going to talk about that a little bit later. So I mean, I guess the question is, if it's so straightforward, why am I talking about it? Well, in the early 1980s, I'll emphasize early, OLC stated that, quote, giving expert testimony was not within the intended purview of 205's predecessor statute. So we're not talking about factual testimony, we're talking about expert testimony here. It wasn't within the ambit of the predecessor statute 283, as I mentioned before. And in a footnote, OLC explained that this view was incorporated into 205 when it passed it in 1962. However, later in the 1980s, OLC narrowed this statement a bit by explaining that if an expert witness is intimately involved in the preparation of a case, the witness may actually serve as an agent or attorney. And what OLC said was that expert witnesses may be expected to do considerably more than testify. They can be architects of the case and prepare specialized studies or develop theories for the case. Such pretrial involvement coupled with testimony at trial might rise to the level of acting as agent or attorney. And that's a quote I pulled from it. So where does this leave us? And the answer is, I'm not entirely certain. My advice is that you should look behind labels and determine whether somebody is simply testifying and providing their expert opinion, or are they acting more like an architect of the case. So this might be more spectral than anybody would like, but that gone from OLC.
I think our viewers and listeners might be getting the sense that this is complicated.
Yes.
And it's not complicated because of the way you're presenting it. It's complicated because it is complicated.
Yeah, it just is complicated.
And that's one of the reasons we like to conduct these advanced practitioner events, is because it gives us an opportunity to explore some of these more complex concepts.
That's right. And so I want to get back to something you said earlier, which is what the judges might or might not like. And so that leads me to talk about 5 CFR 2635-805, which is the provision in OG standards of conduct on the giving of expert witness testimony on behalf of private parties. We talk about that in diagram 07019. And so I guess there's just a lot of pressure points or trigger points when you're talking about expert witness testimony,
Absolutely.
both for 205 and 805. And if you have one, my best advice right now is to call your desk officer, and we'll make sure we provide you with the proper advice and make sure that nobody does anything that they shouldn't.
Right, absolutely. Because this is an area that's very complex. There's a lot of subtlety here, and this is why you have desk officers. This is why OG is here, is to help you navigate those waters.
Absolutely. I think there's a lot of equities involved too, so we just want to be aware of that. And now I'm going to kick it back to Rachel for 205E.
Okay, so another exception that we see a lot is the exception for certain types of personal relationships. So yeah, under this exception, an employee can act as agent or attorney for his parents, his spouse, child, or any person they're serving as guardian, executor, administrator, trustee, or other personal fiduciary. So this is a really practical exception, and it comes from the recognition that government employees will, on occasion, have certain family and other personal responsibilities that are thoroughly proper. But since 205 is so broad, we need an exception for them. So let's look at an example of the application of this exception using our fake employee Bob's family, who all happen to be in trouble with the IRS for some shady tax filings. So Bob here wants to be able to represent his whole family in the IRS proceedings. So we're going to walk through his, a family tree there and see if he can do this. All right, so we see that Bob is married to Tom, and under this exception, you can represent your spouse. And this was recently extended to include same-sex spouses following the Supreme Court's decision in U.S.C. Windsor and OG's Legal Advisory 1310, which implemented the term spouse in all of our ethics provisions to include a same-sex spouse. So Tom's covered. Next up, we see that Bob's mom and his stepdad are also in trouble. So he can represent his mother, his natural parent, but he's not going to be able to represent his stepdad unless his stepdad adopted him or there's some other affirmative legal relationship other than just merely marrying his mother. Here, we're going to say that's not the case, so Bob can't represent his stepdad. Next up, we see Tom's mom, who is Bob's mother-in-law, is also in trouble, but the exception does not extend to parents-in-law. He also has some kids who are in trouble, so he could represent his natural child, Jane, and his adopted child, Joe, but he can't represent his stepdaughter, Julie, unless there is some additional legal relationship like adoption or a judicial decree establishing guardianship, which we don't have here. He could also represent her if she were considered a dependent child as defined in the Ethics and Government Act. But let's just say she doesn't meet that definition here either. So Julie's going to have to find someone else to represent her in the IRS proceedings. Now, with all three, parent, child, or spouse, it means you have to represent them individually. So the exception is not going to work if you're representing a corporation wholly owned by your parent, for example. All right, but keep in mind, though, that this exception has a few limitations. First, the employee may not act under this exception without approval of the government official responsible for his or her appointment. So Bob needs to get approval first. He can't just go out there and represent his spouse.
Yeah, and I just want to point out, I think in the statute that's at the very end.
Yeah,
so
it's kind of buried.
I'm just highlighting that it's at the very end, and it's still a restriction that you have to get before.
Right.
It's an excellent thing to point out.
Yeah. And second of all, the employee may not act under this exception in matters which he or she personally and substantially participated in his or her capacity as a government employee. So that's usually going to be pretty straightforward, and we'll say that Bob hasn't worked on this IRS case. But an employee is also barred from using the exception with regard to matters that are subject to his or her official responsibility. So what does that mean? So OLC has construed this language to include only those areas in which the employee has operational decision-making authority, either directly or through others. So the limitations on the reach of 205E are matters that arise within the employee's chain of command. So, if Bob doesn't work at the IRS, then he's going to be good here too.
So I think that's we took one more minute of your time than we were supposed to. So
I think we started about 75 seconds late today. So we're out of slides.
You're being too kind to us on our first
and out of time. That is a fantastic amount of information to provide in just 1 hour. We share Rachel and Leigh's contact information in case you have further questions. But again, thank you guys so much for joining us. This is a great deal of information. This is an area that we don't have a lot of opportunity to talk about. So I'd like to thank you again, and maybe you'd like to join us again on the Advanced Practitioner Series here at the OGE's Institute for Ethics and Government. So until next time, we will see all of you later, and please look for your course evaluation and share any thoughts you have, anything you'd like to learn more about. There are parts of today's presentation that you'd like us to expand upon. That's something we'd also be happy to explore doing. So please just let us know. But again, thank you guys. That's a huge amount of information and complexity. As always, these broadcasts are available on the YouTube and Google Plus channel for posterity. So if you go back and you say, what did Rachel say when she was talking about that really complicated chart? You can go back and watch it and make notes there. And again, we're always here to help you. So if you have difficulties, please reach out to your desk officer. But again, thanks guys very much for joining us.
Thanks for having us.
Thank you for participating in today's call. You may disconnect at this time.